All right, so Illinois has a new real estate contract. It's called the Multi-Board Residential Real Estate Contract 8.0. And I have a lot of questions. I don't know about you, but I know I do. We've got attorney Aaron McCormick here today, and he's going to answer all of these questions. Let's go, Aaron. How are you today?
Good, how are you?
I'm good. Okay. So Illinois has a new multi-board residential real estate contract, and it's 8.0. So this is our 8th version. We've had others, but this is the 8th. It goes into effect on March the 1st, but we could start using it on February the 1st, and there are a lot of changes. It was 13 pages, and we decided in Illinois we're going to have 14. So Aaron McCormick, take it away. We're going to start at the top and work our way down. So line 4 is a little bit different. It says if dual agency applies, then you complete paragraph 30. And paragraph 30.
It's on page 10.
All right. Okay. So what does paragraph 30 say? It's not any different than it was, is it?
No, this is saying that the parties are basically consenting to dual agent providing brokerage service on behalf and specifically consent to this licensee doing this. So you want to have that filled out so everybody's well aware that the buyer and the seller are using the same licensed agent to represent them. And essentially, if that happens, you're going to be like Switzerland. You're going to be neutral. You really can't do much. You can do the forms, you can do certain things, but you can't be giving a lot of advice and consent and all those type of things because you have to be neutral. You're representing each party.
Yeah, perfect. So really, line 4 is just a checkbox to say, hey, look at paragraph 30.
That's correct.
So then we're down to number 11, line 11. There's a lot of lines, guys. All right, line 11. And it's the same thing it was before. It's just spaced a little bit differently. It's in a little bit different place and just says single family attached, single family detached, or multi-unit. It's actually line 11. So
Correct.
Not really anything different there.
No.
We're going to, hopefully it'll stay that way for a little bit here. Yeah, I know, right? Line 30 is if a home warranty applies, you just check there. And then you go back to page 12, you get to see paragraph 33. But that's the same as it was before. It was always a checkbox on the front page.
That's correct. So I believe 7.0, that is when we started checking if there was a warranty. Prior to that, the 6.1 and the 6.0, and I started practicing law when there was the 4.0. And so that did not have it. So now this is just a continuation of that.
So those things are easy. Now we're getting into the little bit more challenging things. And that is line 31, seller contribution to buyer brokerage compensation, right? And what we have been doing since the National Association of Realtors, since that there was that change, is we'd been having to fill out an addendum, right? Which basically said seller contribution to buyer brokerage, right? And now we've got a place in the contract that we can do that, which is really nice. Although it's a little confusing.
Mm-hmm.
So walk us through that one.
Yeah, so if you're looking at page 1, paragraph 4, lines 31 through 35 of the contract, what you'll see is that initial only one of the following. You have subparagraphs A and subparagraphs B. So under A, the seller would be agreeing to pay the buyer's brokerage a percentage or a dollar amount on the buyer's behalf to be applied to the buyer's brokerage compensation. And then B, the seller will not pay. Well, let's start with B. B is pretty straightforward. The seller's not going to pay anything. And under the terms of the settlement agreement with NAR, it has to be made clear whether or not the seller is going to compensate the cooperating brokerage, and the agent. And so here, this is clearly stated. If it's initialed, there's no expectation of compensation. With subparagraph A, we're either giving a specific percentage or we're giving a specific dollar amount. And probably doing a specific percentage is going to be the easiest.
Right. And I had one recently where someone submitted a contract on a listing that I have, and there were 2 places, and they put this percentage, and then later they put this amount. And I'm like, but what if we negotiate a different price? That amount will change, right? We're not going to sign it because then we would have to give the buyers, representation a different amount than we would if it was a percentage. And they didn't understand how that wouldn't work. Didn't end up negotiating that one. So now we've got at the very bottom of this page, it starts on line 42, fixtures and personal property at no added value. right? And then we go into as they exist at the time of presentation of offer. That's a change.
That is a change.
So talk about that one.
So, as I'm sure you're aware, you've been doing this for a while. It's not your first go around. People will argue, that's not how it was when I saw it, or it's different now than when I went back for a third time, and just every other type of conversation that's had about how does the property have to be turned over to me as part of this transaction or the personal property. So here, if it wasn't working, it wasn't working. If it was working, it should be working, and that's just the simplest way we can discuss this. And that's how the seller needs to be prepared to turn the item over. If your refrigerator is working at the time you showed the house and you're including that in the bill of sale to the buyer at closing, then at the final walkthrough, before you go to the title company, the refrigerator should be working. So it's probably going to behoove the seller to let everybody know what's working, what's not, as far as your listing agent and your attorney. And if something is not working, have your attorney put in their attorney review letter, hey, look at my clients are selling this home to your buyers or your clients. Freezer's not working. That's standing alone. You'll also notice that there's an extended list of items on this document or the 8.0 contract, and I would suggest if you're checking refrigerators or freezers, ovens, stoves, if there's more than one, I would put the number, because what I get to is we have 2 freezers in the garage, we have a freezer in the basement, those weren't included. And yes, you can argue it's normally not included, but don't leave it open to interpretation. That's why in my letters I always put those were not included, just to make sure everyone's on the same page. Here you can put a number next to them if you like.
I like that a lot, that it changed it to check or enumerate. And that was a question that came up earlier today when I was talking to my transaction coordinator, is a dishwasher, and a dishwasher would be working in the beginning and then wasn't working at the end. It is going to complicate things a little bit because when we do the home inspection, yes, the refrigerator was working fine, but now we do the walkthrough and we don't really know if the refrigerator is working fine, or if the dishwasher is, or the refrigerator, or the washer and dryer, because we're not running them. So how are they going to actually know?
Refrigerator is probably an easy one. I mean, if
Yeah.
you want to turn on the washer and dryer, you probably could, but the thing is, you don't own the home yet. So if you break it and the deal falls apart, that's a totally different video on a different topic. But you really don't. And then the issue is if it's not working when you move in, there's going to be the argument. It was working when you did the final walkthrough. You went to go test it now and use it after you moved in. It's not working. That's totally different. And even if you could prove that, are you going to want to file a lawsuit over a $900 item? So you're going to have to use your best due diligence. Maybe you'll bring your home inspector back with you to do the final walkthrough and test these things. Maybe you'll have your attorney add to the attorney review letter. And this could complicate things, so you have to weigh the pros and cons. We're going to bring a home inspector with us, and if these things aren't in working operation as they were at the time of the presentation of the offer, then that's going to have to be taken care of at closing. Just remember, long term, in certain situations when you're dealing with short sales, which that's also another topic, the sellers are not going to be able to probably compensate the buyer. So pros and cons. If you want to get the deal done, maybe not as aggressive. Also, price point of the home, I would add as well. If you're buying an extremely expensive house, upwards of 750 plus, maybe you can be a little bit more aggressive.
All right, so let's move to, well, one, there are a lot more things, a lot more items. We've got, besides the freezers, and we've got smart thermostats and all these other things. So, but if we move to 61, and this we've talked about before, if alternative energy solar panels apply, check here, and then we complete optional paragraph number 34, which is on page 12. So let's go over to page 12, over to paragraph 34, just so we can kind of touch base on that one before we get there.
So the thing with the solar panels is, and I'm happy they put this in here. I have often gotten from buyers, oh, the seller told us the solar panels were paid off in full, or there weren't many payments left. And in my experience dealing with this, nobody pays for solar panels outright. It's never happened. I've never seen it. Could it happen? Sure. I have yet to see it. It's like trying to find the unicorn. So it doesn't really happen. And so the buyer has to understand that as part of this purchase, unless you have it in writing, you are, as the buyer, going to be taking over this lease. And companies like Sunrun want the buyer to qualify to take over the lease. I haven't dealt with a lot of other solar panel companies in this area, but Sunrun is the big one, and they're going to have their requirements. And if the buyer doesn't meet those requirements, or if the lender comes back and says, we don't want to do this deal because the payment is going to kill our client's debt to income, then the deal
Mhm.
won't happen. So those things need to be thinking about and taken care of before moving forward when the home has solar panels. But this is adding language where you have to turn over the documents within a certain number of days, and that not later than 3 business days after acceptance, copies of documents regarding solar panels. So the listing agent should, prior to making the home, I would say even available in the PLN,
Mhm.
have or for people who are watching this who don't know if there's the private listing network, and you can speak more about that, Kathy, have those documents ready. And if you want to use, well, it's not ready for to go public yet. If you think there's going to be a contract, you still got to follow the 3 business day rule. So it would behoove the seller to make sure those documents and all of the necessary paperwork is available to their agents.
I agree 100% on that one because it gets complicated. I've got one under contract right now, a seller who has to take out a personal loan to pay off the solar panels because they don't have enough equity in their home to pay it off, and the buyers won't. They do not want them. There's another complication with solar panels that we've run into, and that's because people purchase solar panels or lease them from a company that is a new company, and then they give them a great deal, and the company goes out of business, right? So the company transfers the billing to one company, but because they're out of business now, somebody else is taking over those payments, but they're not taking over those repairs and maintenance. So
Yep.
now there's nobody that's going to do the repairs and maintenance. So kind of iffy in Illinois. Just something to be aware of. If you have solar panels or you're going to get them, just use a good company, right? Do your research. Talk
Doing
to
your
people.
research is the big one. I would also, just as a last point, add if you're thinking of selling your home,
Yeah,
maybe hold off on the solar panels. I've had clients who put the solar panels on, and within less than a year, they're already selling the home.
100%. And that is exactly what I always tell our clients. So yeah, just wait. If you're going to sell it and in the near future, don't add the solar panels. Not everybody wants them. And depending on the age of your roof, they can also do some damage. So
Correct.
So we're on 70, line 70 on financing contingency, and they did change some of this long paragraph, right? They changed parts of it. So I think the changes might start on about line 79.
Yes. So if the buyer's financing shall be contingent upon buyer obtaining secondary financing or grants as follows. And so what we're talking about here is, do you need more than one loan? Or how are you going to finance this? All of your financing needs to be disclosed up front. Um, Often, I'm sure you've seen this too. You get a pre-approval and it has fill in name of bank or mortgage company, lending institution, etc. And prior to the closing, they changed lenders. And so we need to be clear up front who we're using. And as I explained to clients, changing lenders, we need to get the other side to agree with us, because if you can't meet your closing date, that can be a problem.
Very much so. And I like how they put in the financing or the grants because a lot of times we get offers and we don't realize what type of financing they're actually doing because they
Yes.
haven't been 100% clear on that one.
Yes,
So
like IDA loans that have the grant and are
yeah,
structured differently than a traditional FHA loan or a another type of loan. So these programs that have grants attached to them, as you know, they can take longer to close because there's a lot more people and a lot more process involved in getting those loans done.
100%. I agree. Well, let's take line 85 because it's still part of this paragraph. If the buyer has not received a written rejection of the financing application, but not later than the financing contingency date or yada yada. What does all that mean?
So the contract shall be voidable at the election of either party by giving notice to terminate this contract to the other party. If prior to the seller Very similar to what's in the contract now. When it talks about the contract shall be voidable, voidable and void are different. Voidable means there can be an election to terminate the contract. Void means the contract is over. It's done. It's not happening anymore. So, yes, the seller can terminate, the buyer can terminate.
A little bit of a change in the way they've worded it in the time frame. So,
Sure. I think what we're worried about too with this is long term, but short term, I would say is thinking about market situations. We don't want the seller's home wrapped up with a plethora of extensions, extension. And so this is hopefully going to, I think, alleviate some of that. I think I'm going to be counseling clients, and I know you are, telling them we can't keep skipping around from lender to lender to lender and trying to save a 17th of a point. I mean, I understand we all want the best value, but if you're serious about the home, you might not want to play with continually pulling credit and making a bunch of loan applications. It's not going to work.
yeah, 100%. That is very true. All right, now we got prorations, and that's on the next page, on page 4. I think there was a slight change in, I think, line 149 about below or otherwise agreed to parties in writing. So now we're into proration. So that's paragraph 12, and it's on page 4. Let's look at line 154. In the event the real estate is improved but has not been previously taxed for the entire year.
So on the last contract and the prior contract, when we are buying new construction or homes that have not been fully assessed yet, we agree to a tax escrow. And what you'll often see is that line isn't filled in by either agent. They let the attorneys handle it. So here they've moved this to the prorations paragraph. And so this is automatically going to apply if the property isn't improved. And we're going to agree that 3% should be held. It also talks about that essentially, if you buy from a builder and your tax bill on $1 million house is $1,000, you can be resting assured that that tax bill is going up. You're going to have to be on the lookout for the seller coming up with what the taxes are during that tax year, and we're 1 year in the arrears for the property once it's fully assessed. And so, where you really might see this more, because a lot of builders are not using this contract, you'll see this more if I bought a home and I go to sell it before it's fully assessed. So not necessarily the builder, it's still new construction. I would say if you're buying directly from the builder, they're probably using their own contract and it's not this form.
Yeah, they are typically in this area. Let's go to the next page. So page 5, as is, and we've gone back and forth about this one, all right?
Yes.
Almost every client that we've worked with. So as is, and it says no representations or warranties of the physical condition of the real estate.
So I'll start with this. I think you're still going to see people drafting letters to get around these clauses. I do like some of the changes that have been made here. So we start with paragraph 14, the as is condition. And we're going to look at line 188, which is the contract is for sale and purchase of real estate that is an as is condition as of the date of offer. So very similar to the current paragraph 36, which says, hey, look, you're buying this home as is. Go ahead, do your inspection unless you've waived the inspection, which we'll talk about next. And you buy the home or don't buy the home. And what we see now is my client doesn't accept the condition of the home. If you'd like to give us $1 trillion and put in a new furnace that's 2 days old, we don't like the 2 day old furnace, we'll go ahead and we will buy your home rather than just cancel. But I know you've given us $700,000 price deduction. If you go ahead and give us a large credit and replace the working furnace, then we'll still buy the home. If not, my client will cancel. In conjunction with paragraph 15, this hopefully gets rid of some of that.
Yeah, thanks for mentioning paragraph 15, because paragraph 15 is really interesting to me and it goes into inspection. So go for it.
So paragraph 15A, so you need to make sure to initial one A, B, and C. And I know we're probably going to get all three initialed. I've already thought about this. But the waiver of the professional inspection. This is your old paragraph 11. Surprisingly, I'm starting to see paragraph 11 get initialed again. You saw that at the height of COVID. You saw that when supply was not strong, which it's still not strong. But now that interest rates have gone back up, you don't see it as much, and you're starting to see it again. So we'll see what happens with that. But this is, you bought it as is, and let's say if you've done that, and now we're also not doing any type of inspection. So nobody's coming in, no professionals, sight unseen.
Yep. And then we move to the right to inspect with request.
Yes. So the request, you bring in your home inspector, you could request the furnace, you could request the roof, you could request normal things. I've had clients ask to caulk around the toilet. I mean, that's probably not something you want to be requesting. Replace the mailbox post. Those are all things probably not shouldn't be requested. We're talking about serious mechanical and structural, or what's referred to as the health and safety items.
Yeah.
Those type of things.
I think a lot of times we'll see people who request having GFCI switched out. And then C is a right to inspection with no request, right? Which,
Yes, I think that's how you truly use the as is provision. And this is where I was talking about people will still try to get around. To get their offer accepted, I truly believe some people are going to check off paragraph 14 as is and then initial paragraph 15C. Say the buyer is not going to ask for anything. They're still going to bring in the home inspector because they want to make sure. And they're going to do their inspection, or they might bring in some additional professional to look at a fireplace or the sewer line. And then they're going to come back with telling their attorney a letter that we don't like X, Y, and Z. We find it to be something we can't accept. And if the seller wants to take care of it or give us a credit, we'll buy the home. If not, we're out. So I think what you're going to find is, and this is just my opinion right now, because these three have been added, is even though it's a real estate contract, contract law still applies, and you still have acting in good faith as a principle of contracting. So I think if you get the right seller's attorney on the other side of the deal, they might argue it's not in good faith, and you're potentially going to see people fighting about releasing earnest money. Because I think as you read this, you could potentially lose earnest money, even though at the very end it says, and seller to declare this contract terminated and direct the return of buyer's earnest money. That's if you actually declare the contract terminated, not sending out buy if you don't fix these things. That's not in good faith. Good faith is you said you'd inspect and not buy the home if you don't like the condition of it.
that's a really excellent point. Wow, this is a lot of changes and a lot to think about.
Yes.
So we have another one. So under on line 245, 16, additional inspections not subject to those previous paragraphs. And I think one of the biggest ones is under the well or sanitary system inspection. We
Yes.
have some of those, right? And it's now $5,000, right?
Yes, I think what we've seen is just again going back to COVID. After COVID, you can't do the same things for $3,000 that you could prior to. So I
Yeah.
think now we're upping the limit because if well or septic things need to be done, it could be more money, just because the cost of labor and materials have increased. And this gives the buyers also the advantage of, well, the seller can't get out, because I have had it where it costs more than 3,000. So I have never seen well and septic repairs cost more than 5,000. It doesn't mean it doesn't happen, but 5,000 probably keeps the deal together.
Yeah, good. All right. Now we're going to skip a couple pages because I didn't make any changes. We're on page 8, paragraph 24. Seller representations regarding notifications and knowledge. And it says the seller is not aware of, nor have they received any written notification from any association or government entity regarding a whole list of things.
Yep. So, often I'll get letters from the seller's attorney, or I'll send out a letter and say, my client doesn't know. You would think that the client knows, but honestly, do sellers really know if they have zoning or health code violations? Do they know if they have pending rezoning? You would hope that they got mailed those things, but they're not attorneys. They don't work in real estate every day, so they may or may not know these things. So if they do, they're supposed to disclose it. But other than that, not a lot has changed here. They did get rid of the boxes that you check yes or no, or has or
Right.
has not, but are or not. But other than that, really nothing has changed here.
So what if you have received notice? Do you just line through it and initial it or what?
I think if you're aware of it, you're probably going to want to talk to the listing agent. Should bring these things with them after the clients are going to list and say, do you know of any of these things, to
Yeah.
avoid issues after the contract is accepted? Talk to your client who's going to be listing and say, do you know of any of these things? And if they say no, great. If they do, that's when they probably want to talk to the attorney before listing the home or accepting offers. You've listed it, but before you accept offers, have them talk to the attorney so that you can figure out a game plan on how to handle this.
I think that's excellent advice. And I always suggest to people who are listing their home to talk to the attorney beforehand,
Yes.
right? Because you want to have somebody that, is in tune with what you're doing. So next we've got, I think paragraph 27, and it talks about the direction to the escrowee. And they've added a little bit on line 386, if the escrowee is a licensed Illinois real estate brokerage. So what's different there?
So what I think we're seeing here is that this is specifically stating if there's a real estate broker, not just whoever the escrowee is, who's holding that earnest money check. Here we're specifically saying if you're a licensed real estate brokerage, how this works to release money. Because I think a lot of the times what we were saying is we need the mutual cancellation agreement signed to release money. Now we're eliminating that. So this process is now spelled out in black and white in a contract. Whereas before, it was really dealing with the attorneys, the title company, who's acting as escrow, but it didn't specifically state for a licensed real estate brokerage how it would be handled.
Got it. So they're just basically CYA.
CYA and trying to firm it up.
Yeah, okay. And if we go to the next page, page 10, we've got performance on paragraph 29, and it's line 419, and it says time is of the essence of this contract. And then it continues into in any action arising out of or relating to this contract, including but not limited to any claims or causes of action in law or in equity. So what's that whole paragraph about?
Yep. So, for example, if I sue you for breach of contract, I might ask a court to say, I would like $50,000. That's the amount of money or damages that I have. I could also ask the court for an order of specific performance, and that would be an equitable remedy. So, those are the type of things they're putting here. The parties are free to pursue any legal remedies available, and the prevailing party in such litigation shall be entitled to collect reasonable attorney's fees from the non-prevailing party. Realistically, I have not seen anybody sue anybody in 11 years that I've been doing this. Real estate litigation on a residential contract is very seldom. I think one, if you're dealing with a builder, you're more likely to potentially get sued if you breach contract, or when you get into those million-plus-dollar homes, people who are buying and selling million-dollar-plus homes, especially if it's in cash, you might see some litigation there. Your average person buying a five, six, $700,000 home, probably not going to see litigation.
Yeah, I would agree. Okay. Well, we've got a few more things yet to go. So paragraph 31, but all the way down to the end of that paragraph under A is 445. And you can check this box that says that the buyer real estate is not publicly listed for sale. So this is under the sale of the buyer's real estate. So it's a contingency, right? And it says that they do not intend to list buyers their real estate for sale with a licensed real estate brokerage.
Hmm.
So they could do a for sale by owner.
Correct. And I think from a strategic standpoint, if you have somebody using an agent to buy a home, and somebody sell a home, and so this seller is going to be selling for sale by owner, you get the question of, is this person going to be capable of selling their home to get this contract closed? They're not using a professional who does this every day. And so you can't discriminate and say, well, they're not using an agent, but that might be part of the calculation saying, well, you have another contingent offer, the person's using an agent, they have all the resources and tools, they know how to market the home correctly, and they probably can get in front of more people. And that might be something that you want to think about before you do a for sale by owner with a home sale close contingency.
Yeah, that makes a lot of sense. And I like that they added that in there. So we might as well go on to one of them that kind of talks about this one, and that's the reverse contingency. So what's a reverse contingency and how has that changed?
So over my career, I've had clients who are selling a house saying, "Hey, look at, we thought we'd be able to find something. We thought we'd have more money. We thought we'd have more time." And they need to be able to get a home before they can close on the home they're selling. And so, just like a home sale close contingency for a buyer, where they only buy and close on the home if they sell their home and close on it, here the sellers now get to do that with this reverse contingency addendum. The addendum needs to be filled out and submitted basically before you accept the offer. So as you're accepting it, you need to have the buyer sign off on this. Is how you want to handle this, and it becomes part of the contract. And the contract is then contingent upon the seller entering into a contract on or before. So you fill in the date for the purchase or rental of a replacement property. So it doesn't have to be necessarily a purchase. It could be a rental. You're going to want the attorney who's representing the seller to put some language into that attorney review letter, and in respect to which all attorney review and inspection conditions have been satisfied or waived. So that's another big one. Once we've closed attorney review, then you would be able to enforce this and say, look, we've closed attorney review. I have a reverse contingency, and as we're getting down to the wire, if you can't find a replacement property or rental, then as long as you do it by the date that you agree on, you give notice before then. If the sellers haven't found something and they give the correct notice, they can get out of the contract. Because I have also had sellers say, "Hey, I want to get out of the contract." And I went over what is a reverse contingency. You told me not to do it. We closed attorney review, and we're a week away from closing.
Right.
That's called breach of contract, and that's where you will potentially get sued.
Very true. And I like that they added the new addendums. They actually added those as contract addendums on page 13. So that's
Yes,
helpful. Okay.
which is very nice.
So, all right, we've got still have more things to go through, right? So on page 11, in paragraph 32, cancellation of prior real estate contract, it's line 499 for anybody who's keeping track. And it says initial applicable subparagraphs. So talk about that because some of this is not the same as it was before.
No, this is an expanded version of cancellation of prior real estate contract. So we would start by, if any of this applies, initially in line 498, paragraph 32, and then in the event the sellers entered into a prior real estate contract that's contingent upon the sale or closing of the seller's purchase of real estate. So that's where the reverse contingency addendum comes in. You got to fill that out. And then there's subparagraph B. In the event the seller has entered into a prior real estate contract that is not contingent upon the sale or closing of a sale of the purchaser's real estate, you fill that in. So that's like the old. Is there a contingency? And then is that contract, does that buyer's buyer have a home sale, home close contingency, very similar to that? So you would have to fill that in. And then in the event the buyers entered into prior contracts under subparagraph C for the purchase of real estate, this contract shall be contingent upon the notice to the buyer, by buyer to the seller on or before. So you'd fill in that date for that paragraph. So we're not checking off each paragraph, we're checking off the ones that are applicable.
We could also say that the buyer's contract has been terminated. So that
Correct.
covers if a seller if they're under a contract, and it also covers if a buyer is under
That is
contract.
correct.
So we have an appraisal addendum, which someone asked me for this morning.
Yes. So that is the appraisal gap unto itself, essentially. We're going to check that off if we have an appraisal gap. Are we paying a certain amount? Are we moving forward if it appraises for anything under the contract purchase price? What is the dollar amount that the buyer is going to have to come up with if it under appraises? So we're going to set out all those terms up front. We're going to want to make sure that's checked and part of the offer and is accepted at the time the offer is accepted.
Yeah, and we've used this, I think it's very similar with this one. They haven't changed a whole lot. We've been using appraisal addendums for a while.
Yes.
Not really a lot different. Okay. Now we have the intent to escalate. So it says it's not binding. It's just, it's not even an addendum, but it is sort of an addendum, all right? So how does that work? Your intent to escalate. We've had called them an escalation clause,
Yeah,
escalation
escalation clause,
addendum
escalation
before.
rider,
Yeah,
escalation addendum.
yeah.
So basically, if you're going to enter into an escalation agreement, you're working with your agent who I'm sure has pulled comps and says, look, it's listed for $375,000. Homes in the area have sold for 400, and sometimes we have listing agents intentionally listing properties lower to drive the price up, seeing what the market will bear. You can make an offer saying, I'll pay 375, but I will pay up to 400,000, and whatever your highest and best offer is, I'll pay $2,000 over it. So if the highest and best offer is 395 and you're paying 2,000 over, the buyer is agreeing to pay 397. If you're agreeing to pay 400 and the best offer was 400,000, but your stopping point is 400,000, you're stopping at 400,000. You can't go over that. You don't have to.
Yeah, I typically explain it to my clients as it's an auction like eBay, right? This
Yes.
is where you set it, and we go through that with smaller numbers, so it's easier to track. But yes, all right. We have another addendum, multi-units. We do a lot of multi-unit sales around here, so that's another addendum that we are going to be including. Is this different or is it the same as we've had before?
So a couple of things. The reason it doesn't say 5 or fewer units is because at 5, just for people who are watching this who have no experience with real estate, you'd be at a commercial transaction, and this is a residential transaction that we're talking about. So this is one. Buyer agrees to take possession subject to leases and tenancies to which the buyer has not objected. It's going to be very, very, I call it uber important to make sure that the buyer's attorney is getting leases and sending notice to the other attorney saying, I will move forward or I won't. What you need to be on the lookout for is month-to-month tenancies with no written leases, nothing like that. That's where it might become an issue, because then if you're moving forward, the buyer is going to be dealing with no written lease, and that could be an issue. Because now you're saying you're taking subject to leases that you haven't objected to. So again, just like before, if there was no written lease, you were taking subject to that lease unless you got the tenant out of there. But here you need to say you object specifically to unwritten leases, or however that's going to be handled.
That makes sense. And I think as best practices, as we've talked about before, is when we work with people who have multi-units and they're selling them, that they provide the listing agent with copies of everything up front.
Yes.
Because that rent roll, the copies of the leases, all the information, because otherwise they're not going to probably meet that 5 days, the 5 business days that's included in here. So,
And the security deposits and rent prorations are through the date of closing now, not starting the day after closing, where you see that sometimes. It's through the date of the closing.
okay, that's good to know. And then I think this might be the last one.
All right.
All right, we're good.
Thanks for watching. If you're enjoying this content, feel free to subscribe and give us a thumbs up.